The Institute
for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, brought to you by IJ's Center for Judicial Engagement. I'm your host, Jeff Redfern, filling in for John Ross, and we have a special show for you today. As you know, in our normal programming, we bring you analysis of interesting and important decisions from the U.S. Courts of Appeals. But today we're going to mix things up a bit and talk about the most important administrative law decisions handed down by the Supreme Court last term. Joining me today are a couple of the biggest administrative law nerds you'll ever meet. Professor Adam White from the Antonin Scalia Law School at George Mason University, and Michael Kimberly, co-chair of the Supreme Court Litigation Group at McDermott, Will & Emery. If you like this podcast, please do us a favor and leave a review on iTunes. So we'll kick things off with Kaiser v. Wilkie. Michael Kimberly actually represented James Kaiser in this case before the Supreme Court. Michael, what's Kaiser all about?
Thanks, Jeff, and thanks for having me. I think Kaiser is broadly recognized as one of the most important administrative law cases in the last decade. It asked the question whether the Supreme Court should overrule Auer deference. Auer deference is a doctrine that began really in 1945 with a case by another name, Seminole Rock. That case first introduced the idea that courts should defer to agencies on the interpretation of their own regulations. But Seminole Rock itself used the traditional tools of statutory construction and then evaluated the question whether the agency's interpretation of its own regulation was a reasonable one. But over the ensuing decades, courts continued to apply Seminole Rock deference in a manner that really became much more of a reflexive doctrine of deference, in which courts would simply ask, well, what does the agency say about the meaning of its own ambiguous regulation? And then, as long as there's any semblance of reasonableness, end up deferring to that interpretation. But that reflexive approach to Auer deference has implicated a number of well-known concerns and problems. Not least is that it's a circumvention of the Administrative Procedures Act promise of notice and comment rulemaking, insofar as it allowed, I should say, now that Kaiser is behind us, allowed agencies to promulgate vague regulations through notice and comment, and then supply those vague regulations with meaning through later interpretive acts that didn't go through notice and comment. And this, I think it was broadly recognized, was a strong incentive to agencies to pursue vague regulations. And of course, it implicated also a sort of separation of powers problem where the same agency or the same body that was promulgating rules was effectively in charge of interpreting them. So over the years, I should say, Auer deference really hit its high watermark with Auer against Robbins in 1997, ironically a case written by Justice Antonin Scalia, who became one of the most outspoken critics of the doctrine, in which the court ended up deferring to the government's interpretation of its own regulation as expressed in an amicus brief filed for the first time midstream in litigation, which seemed like an awfully unfair approach to deference. So over the course of a number of concurring and dissenting opinions in the 2000s, a number of justices made clear that they were open to reconsidering Auer deference, and that's what the court granted in Kaiser against Wilkie. And in that case, the court was really confronted with three different options. One was retain Auer deference and change nothing. Another was what we had advocated initially in the petition, which was to overturn Auer deference. And the third sort of compromise position was the one proposed by the Solicitor General's office in its brief before the Supreme Court, which proposed a 5-part test for applying Auer deference. The court ended up siding with the Solicitor General and taking the consensus approach, which requires now courts to find a genuine ambiguity, step one. Step two, must analyze the construction proffered by the agency and determine whether it's a reasonable one, and that's really a step that has teeth now. And three new steps, which are that the courts must determine whether the person or office within a department that's issuing an interpretation is really sufficiently authoritative to take a position on behalf of the relevant agency. The court must also ask whether the interpretation is one that reflects the agency's substantive expertise and what you might call a response to Auer itself. There can't be any surprises. So midstream amicus briefs, I think, are now off the table. So that's what the court ended up adopting, and I'll add just one final point. It was a 5-4 decision. The majority opinion was written by Justice Kagan. Chief Justice Roberts wrote a concurring opinion in which he argued that there really wasn't a whole lot of space in between Justice Gorsuch's dissent and the majority opinion, and that's a telling point because Justice Gorsuch really didn't pull punches in his dissent. He says under this new 5-part test, our deference has been quote unquote zombified, and it's now a paper tiger. So there's really, I think, a question whether after Kaiser against Wilkie, there's really anything left of our deference other than sort of a softened version of the very original 1945 Skidmore deference.
So does that mean that this fight about our deference is basically over?
No, I think as Justice Gorsuch predicted in his statement during the oral argument, this 5-part test, I'm sure, is going to be fertile ground for lawyers to bring all kinds of new challenges.
Oh, I agree totally. The devil's always in the details, and this new standard has a lot more details. One of the interesting things in the debates surrounding our deference, or what I suppose we should now call Kaiser deference, and in the related debates about Chevron, is that the advocates of those deference doctrines, especially Scalia, they always promoted simplicity. They thought it was important that these doctrines be simple and straightforward so that everybody knew where things stood as soon as a law was made, whether it was a statute or a regulation. This new approach to deference, this new Kaiser deference, is now so much more complicated that, like you said, there's going to be total opacity about how much deference the agency is actually going to get until we get to the point of litigation. And I'd add, I also think it's interesting that we'll have real division of opinion among judges over what's actually persuasive. And this gets to the case we'll be talking to a little bit later, Department of Commerce, but this real split on the Supreme Court and in the courts in general over the extent to which we should be persuaded by the value judgments or policy judgments of an agency, and to what extent is deference really just a matter of deferring to technocratic expertise.
What about this emphasis on genuine ambiguity? The dissent seems to suggest that if we take this seriously, then this doctrine is essentially meaningless, that courts, when they apply the normal tools, they always get to some kind of an answer about what a statute or a regulation means. And the majority seem to embrace a pretty strict reading of genuine ambiguity. Could that get us around some of the questions about these other factors that might come in on the back end?
I think definitely. I think even before Kaiser, what we had been seeing both in the courts of appeals and now on the Supreme Court with the likes of Justices Kavanaugh and Gorsuch are that judges and justices are increasingly more reluctant to agree that any ambiguities in fact do exist in law. And, you know, an interesting facet of Kaiser that isn't immediately apparent to those who weren't really in the weeds on the case is the case initially presented 2 questions. The second question presented was whether, and actually I can't recall whether it was the first question or the second question, but one of the other questions presented in the case was whether the court should apply value-based canons of construction. You might think of the canon, the rule of lenity is one example. In this case, it was the canon in favor of veterans, which works much the same way as the rule of lenity. Whether those types of canons apply before deference does. And it seems to me the way that the court approached this case and the very muscular framing with which they described the way ambiguities must be determined now under this new test, I think these sorts of canons ought to apply first. Every canon ought to apply first. And there are precious few questions of statutory and regulatory interpretation that will be left after application of that full range of interpretive tools.
I totally agree. And I'd add that where so much of these deference doctrines really began with the intent of the lawmaker, what do they intend? Is their intent clear? you have to ask yourself, what do we mean by these canons of construction? Are they really tools to get at the intent of the lawmaker, or are they just tools that we apply after the fact? Because the fact is, Congress, agencies, when they write regulations, they're not getting out, by and large, the big book of canons of construction and writing their laws accordingly. There is some of that. But really, the canons are something we apply afterwards to sort of force fit some reasonableness onto otherwise ambiguous statutory text. And so once again, I think you've nailed it. I think that this is going to be a real battleground for the aftermath of Kaiser.
What does this mean for Chevron?
Well, this was an issue I think that we were cautious about in litigating the case. The way we described it is we built a firewall around Chevron to make it clear to the court that in order to overrule Auer, it really didn't have to say anything about Chevron. I think Chevron implicates very different concerns. Auer was about circumventing the Administrative Procedure Act. Chevron is, in a sense, quite consistent with the Administrative Procedure Act. When agencies follow the procedures laid out by Congress for them to promulgate regulations under the statutes that grant them the authority to do so, there's a far more sensible basis, I think, for deference. There also is not the same sort of separation of powers concern that was present in the Auer context, where you have both the law maker and the law expositor in a single branch. So my own sense is, as a doctrinal matter, there isn't a whole lot here to cast doubt on Chevron deference. And I would say even further, as a practical matter, if you couldn't get 5 votes to overrule Auer deference, I think it's going to be a long time, if ever, before you get 5 votes to overturn Chevron deference.
Yeah, that's the great irony of this. In some ways, with all due respect to the Kaiser case, Chevron is sort of the bigger fish of the two. It's the one that probably cries out for more immediate judicial sort of reconsideration, although I'm ultimately pretty sympathetic towards Chevron. But I think you're exactly right. If the court isn't going to make a radical adjustment to Auer deference here, it is very hard to imagine 5 votes to make radical changes to Chevron. If anything, one of the things that's interesting about your case is that the court basically realigned Auer deference with Chevron. They Chevronized this old doctrine by talking about it in terms of ambiguity, by creating almost an Auer step zero, all these prerequisites to deference. And so I think this is actually a pretty good indication of where we might be headed, but the bottom line would be then that where we're headed is not a whole lot of change on Chevron.
Do you think Kagan was trying to save Chevron by making Auer so much stronger?
I think Justice Kagan was interested in stare decisis writ large. I think there is broad concern about what are rightly characterized as broadside attacks on the administrative state in litigation recently, including the nondelegation doctrine, which I know we'll be getting to later. I guess my own sense was her concern, as it was, I think, throughout last term, was more broadly with ensuring that the court doesn't overturn precedent, except really in the very most egregious circumstances. And as she made very clear at the oral argument, this was not close to that.
All right, let's move on to our next case, Department of Commerce v. New York, or as you may know it, the census case. Now, there were some constitutional issues in this case, but there were also some administrative law issues. Professor White, tell us about it.
Well, I'm glad you called it the census case, or maybe we should call it the citizenship case, right? In the middle of this long, now 2 years debate over the current administration's view of citizenship, immigration, and so on, we get this case that we think of as the citizenship case, the census case. The court ultimately decides it on pretty narrow administrative law grounds. But ironically, the way they went about it makes it a much more consequential case for many more cases in the future. If the court really had decided this on constitutional grounds or big picture grounds, it's hard to imagine any other case sort of coming up with similar facts. But what the court did here actually could be made broadly applicable to a lot of decisions that agencies make on a day-in and day-out basis. Okay, here's the basic background of the case. As your constitutionally minded audience knows, Article 1 of the Constitution provides that there will be an actual enumeration of persons in the United States every 10 years. And that enumeration, the census, is the basis of a number of things. One is we know how many people are in the country. 2 is we learn a lot about the people in our country. And 3rd, that information then helps Congress and other actors make decisions about things like the drawing of district lines for elections, federal funding programs, as the Justice Department argued, has implications for the Voting Rights Act, and so on. And so not long after taking office, Department of Commerce's Secretary Wilbur Ross announced that the Department of Commerce, which carries out the census, was going to add back in a question about whether the people answering the citizenship questions were citizens. Now, this question had left the census about 8 years ago. In 2010, it was taken off the census and added instead to what we call the American Community Survey. It's a document, more detailed document that goes out to a much smaller subset of Americans. Before that, for about 50 years, it had been on what we call the long form of the census, part of the census, but only goes out to a smaller part of the American public. Before that, dating back to about 1820, the citizenship question was almost always asked of all people answering the census. Now, of course, what some would say is that in the current environment, asking the citizenship question is different. Now that citizenship and immigration is a much more controversial and politically fraught issue and policy today, there were concerns, which the Census Bureau within the Commerce Department voiced, concerns that asking this question would actually make people reluctant to answer the census questions at all, and that by adding this question, you actually are going to make the census as a whole less reliable. Now, Secretary Wilbur Ross's argument was that the Commerce Department and the Justice Department needed to have this citizenship information in order to best carry out the requirements of the Voting Rights Act, making sure that that the government, especially the Justice Department, knows when they're trying to establish whether minority-majority districts are drawn correctly to give racial and other minority groups proper voice in elections. That the citizenship question is important. You need to know how many voters or possible voters are in any district. So Wilbur Ross in March of 2018 announces that we're adding this back in to the census. And he justifies it in part on the advice of the Justice Department Civil Rights Division. Immediately this explodes into a controversy and, of course, a lawsuit. And it goes to a couple federal district courts, winds its way up to the Supreme Court. Now, what made this case interesting as an administrative law question was the courts, ultimately the Supreme Court, were asking, what sort of information can we look at to glean what the agency's actual reasoning was? Under the Administrative Procedure Act, agencies have to explain what they did and why. And mostly the courts don't peer within the mental processes of the agency leadership. That'd be a dark and weird place anyway to peer. But it's sort of taken as an article of faith going back through all of modern administrative law that agency heads, cabinet secretaries, and so on often have a number of reasons why they do something. And we're not going to try to peer inside of their mind to get the so-called real reason. As long as the reason they offer is on its face plausible and justified on the record, the court is going to affirm. In this case, though, information that made its way into the record suggested that maybe Wilbur Ross had come to this decision originally for other reasons, and that the Voting Rights Act justification was sort of a late addition. It was reverse engineered to explain this decision that they had already made. Basically, that as the word is, it was a pretext. And so when this case gets to the Supreme Court, the court decides up front that no, this approach does not violate the Constitution itself. I won't get into the details unless you really want to, but there was an argument that the enumeration clause itself prohibits this kind of question because it depresses the number of answers you're going to get. The court says, no, that's not a problem here. The majority of the court also holds that this is not arbitrary and capricious, that the Commerce Secretary in general could be justified in adding this kind of citizenship question to the census. And in fact, there was sufficient evidence in the record to justify that kind of decision. The problem was pretext, and the court made clear up front, this is Chief Justice Roberts writing for a 5-justice majority, the court made clear up front this is a very extraordinary situation. But they said in this case, there is more than enough evidence of bad faith that the courts were justified in giving this even more scrutiny than usual. And they said in this case, we think that the Secretary's explanation was a pretext. If he had given what the court seems to think was the genuine reason for this, that the Secretary just cared a lot about the citizenship issue and that he had discretion to add it and that the costs of adding this question were outweighed by the benefits, that probably would have passed muster. But because the Commerce Secretary gave what the court saw as a pretextual explanation, they say For that reason, we're going to wipe away the decision and send it back to the agency for a do-over. Now, in this case, as your listeners might remember, it was very interesting in the days following the decision. It wasn't clear whether Commerce was actually going to redo it or not. At first, they indicated that they wouldn't, based in part on the fact that the Justice Department had told the court there wasn't time for a do-over. And then President Trump, as you may have heard often does, took to Twitter and said, no, we are going to redo this. And so there was this very interesting few days where nobody knew exactly what would happen. Ultimately, the Commerce Department and the Justice Department said that the administration is going along with the court's decision and also not trying for a do-over. I think the administration ultimately was satisfied they can get this information through these other things like the American Community Survey. But the point of all is the upshot of what makes this case important is really what it means for future cases. There's a big question, and Justice Thomas raises this in his dissent. He and the other conservatives dissented from that aspect of Roberts' decision. They said here there just wasn't enough evidence of bad faith, that cabinet secretaries often have multiple reasons for doing something. In this case, the Voting Rights Act argument itself was sufficient to justify Wilbur Ross's action. And what the court is doing here is opening the door to now every hotly contested administrative question being judged in terms of pretext. And Thomas actually throws out the example of the net neutrality regulations. Was that really justified based on the FCC's reasons? Or, as was widely reported at the time, was the FCC pivoting at the last second towards President Obama's political agenda? Now, at the same time, I want to point out some of the dissenters, led by Justice Breyer, they actually thought that Wilbur Ross's argument was just arbitrary and capricious in general. And it gets back to that point I made earlier about policy judgment. Here, the dissenters from the other direction, Breyer and the other progressives, thought that Wilbur Ross's judgment overall really was unjustifiable in light of the experts at the Census Bureau. And I think really raises questions, again, maybe in conjunction with the Kaiser case, about what courts actually think is persuasive. Is it policy judgment, or is it just, which is usually value-laden, politics-laden, or is it just a matter of deferring to and affirming technocratic judgment? That's two wildly different views of the administrative state. And to end with a line from Kaiser, the one that you already referred to, where Roberts says there isn't a whole lot of difference between, say, Gorsuch and Kagan in the Kaiser case. That's true at a very superficial level, but at a deep level, it's wildly untrue because the Gorsuch coalition on the court and, say, the Kagan coalition on the court or the Breyer coalition just have profoundly different instincts about what is persuasive in agency action.
So do you think this is an administrative law revolution, or is this more of a aberration, a bolt from the blue that we're not going to see repeated?
I think in the short run, we are going to see a lot of cases that raise this question. I think the court and the lower courts are probably going to put this one in a tight box. Maybe not this ticket good for one ride only, but this ticket good for a couple of rides every once in a while. I think the court is going to slowly back away from this a little bit, in part because of the warnings of Justice Thomas and others. But we'll see. It's going to be very interesting, especially not just with this administration, which carries with it all sorts of baggage in our political world, but the next administration and the ones after that. How are they going to go about, much like the Kaiser deference issue, how are they going to go about making sure they say the right things on the record up front to try to depress and avoid this kind of thing? If it doesn't have a big impact in the courts going forward, I think it'll be because agencies will now put this on their checklist of things to take care of at the agency level.
I have to say I have a little bit of a different instinct, and it's because I think where there's real opportunity for the census decision to have an impact on administrative law is not on the big-ticket rulemakings that are certain to get a lot of attention in the courts and press. It's on the smaller stuff. There's a wide range of cases that are litigated under the Administrative Procedure Act. Every decision that the FDA makes about a drug is subject to litigation under the APA. And it turns out that lower-level bureaucrats and members of agencies can often act like petty tyrants. And seeing this sort of conduct at a much lower level is really not unusual at all. And it'll be interesting to see how aggressively day-to-day litigants with their day-to-day APA cases rely on this precedent to open up the record beyond what is often a very carefully and sometimes inaccurately curated administrative record.
Yeah, that's a great point. I should say in my past life as an actual lawyer, I used to work on like pipeline cases and that sort of thing. I was a FERC lawyer. I litigated against FERC. And that's absolutely right. It gets back to that earlier point I was trying to make about will the courts be as suspicious of the prejudices of, say, a cabinet secretary as they are of somebody much lower down who says, listen, I'm just the assistant administrator for air quality at the EPA. I'm not a politician. I'm just here for my expertise. And that, in a way, is harder to get behind. But I agree totally that it's even more crucial to get behind it because it is so opaque.
And this gets back to what you were saying earlier, Adam, about the way the different sides of the court view administrative law. Justice Thomas seems to think that if the secretary has his own ideas and his own prejudices when he comes in here, well, that's just politics, and that's why these people are supposed to be appointed through the political process. But it's not entirely clear then what sorts of purposes are actually improper. What's going to cause a decision to be overturned by a court?
Yeah, I'd say one of the great meta questions in constitutional litigation right now is what justifications will move a court. We see this in constitutional law, especially on religious liberty and other issues that bump up against religious liberty, where courts seem less persuaded by the arguments that come from tradition, right, that we've always done things this way. The court says, no, we want sort of rational scientific answers. We want statistical answers. The same thing here, whereas Roberts and the majority that support most of his opinion say it's perfectly fine for a Secretary of Commerce to come with preformed views on these issues. That's why elections happen, and that's why these people are then appointed to lead the government. Other coalitions on the Supreme Court and much of the lower courts, again, they want sort of scientific or technocratic expertise. They're not impressed by arguments from elections.
I would add, though, I think we have to be clear about what was going on in the census case in particular. One, a finding of pretext presupposes that there's something to hide. I don't think there are too many people who would argue that a Secretary of Commerce can't come in with a mind about what's good for the census. I think the problem and what ultimately forced the court's hand in this particular case is that the evidence was quite clear that this was about depressing the count of, in particular, Hispanic voters who trended towards Democrats. That sort of overtone to the decision, and the fact that the secretary himself thought that it was the kind of decision that he needed to dress up in more palatable clothing is, I think, the kind of rationale that's easy to appreciate is an inappropriate one.
Yeah. They acted like they had something to hide because they did have something to hide.
Yeah, I really think it's an example of something that we see in a lot of different contexts in constitutional law where the court will initially be concerned that, look, if we start wading into this area, we're going to cause all kinds of problems. We're not really suited for this. And that's really the concern that Thomas is expressing. And as soon as they say, wait, we're just not going to do it. It doesn't make sense. Then you start to see the really egregious abuses, and then the pendulum starts to swing back, and the court says, wait, okay, maybe we didn't really mean never. We need to prevent some of these outlying cases from happening. Okay, the last case I'd like to talk about today is Gundy v. United States. This case was a real judicial cliffhanger. If you've ever finished a season on Netflix and said, I can't believe they're going to make me wait a year to find out what happens, then you might understand how Michael, Adam, and I felt after Gundy. This case concerns the Federal Sex Offender Registration and Notification Act, which we affectionately call SORNA. This is a big statute with a lot of very specific rules for sex offender registration, and it includes criminal penalties for failing to register. SORNA is not clear, however, about how it applies to people who committed sex crimes before SORNA was enacted. All SORNA has is a provision saying that the Attorney General shall have the authority to specify the applicability of SORNA to pre-act offenders. So the Attorney General used this authority and published a regulation saying SORNA applies in full to pre-act offenders. That's pretty much it. Well, this regulation turned out to be a problem for a man named Herman Gundy. He was a pre-act offender convicted of failing to register, but he made an argument that caught the Supreme Court's attention. He claimed that SORNA was unconstitutional because it gave the Attorney General total discretion to decide whether an act was criminal or not. By letting the AG decide if SORNA applies to pre-act offenders, he said, you're basically letting the nation's chief prosecutor write the criminal laws that he's also enforcing. So, of course, the Constitution says that Congress makes the laws, not the Attorney General. But at the same time, administrative agencies have been doing a lot of what looks like lawmaking for a very long time. As some of my colleagues at the Institute for Justice pointed out in an amicus brief in this case, federal agencies in 2016 promulgated about 100,000 pages of regulations, compared to just 6,000 pages of laws enacted by Congress. So it looks like the majority of federal law these days is being made by regulators, not by Congress. How is this constitutional? Well, as far back as 1825, Chief Justice John Marshall held that Congress doesn't have to include everything when it writes a law. Congress can let agencies, quote, fill up the details. But the question really came to a head in 1935 when the court struck down a pair of statutes holding that Congress had unconstitutionally delegated its legislative power to agencies. In one of these cases, the court said that delegation is constitutional so long as Congress lays down an intelligible principle for the agency to follow. So in other words, agencies are not supposed to have unbounded discretion. But since those two cases in 1935, the Supreme Court has never struck down a statute as unconstitutional, or as an unconstitutional delegation of legislative power. And that includes some really broad statutes. For instance, Congress has outlawed unfair or deceptive acts affecting commerce, and it gave the FTC the power to define what those acts are. Well, unfortunately for Herman Gundy, the court did not decide to break its streak this year. But the court did say a lot of interesting things. Justice Kagan, writing for a plurality of Breyer, Ginsburg, and Sotomayor, said that SORNA doesn't actually give the Attorney General much discretion at all. She thought that if you read the whole statute and pay attention to its context, it really just means that the AG is supposed to require registration from everyone to the maximum extent possible. And because she read the statute so narrowly, she said it was easy to conclude that SORNA was constitutional. Now, Justice Alito was the fifth vote, but he did not join Kagan's opinion, which means Kagan's opinion is not controlling. And he wrote just a couple of paragraphs. He basically said that he was open to reconsidering whether the Supreme Court should reinvigorate the non-delegation doctrine in a future case, but that under existing precedent, he thought SORNA was constitutional. He didn't even say whether he agreed with Kagan's statutory interpretation. Justice Gorsuch wrote a dissent on behalf of Justice Thomas and the Chief, and he really came out swinging, saying that he would go back to an originalist version of the non-delegation doctrine, where agencies really are limited to just filling in the details, not making legislative policy. Now, I've got to say, I'm not really surprised that Gorsuch went in this direction. He's been a long critic of the administrative state. He thinks that agencies have way too much power and are doing things they're not supposed to do under the Constitution. He was also the second federal judge after Justice Thomas to cite in a judicial opinion Philip Hamburger's book about administrative law. He had this book a few years ago called Is Administrative Law Unlawful? Spoiler alert, he thinks it is. What was a little surprising to me, though, is that the Chief joined this opinion because it was much more aggressive than I would have expected from him. So if you're counting, I've only mentioned 8 justices so far. Kavanaugh was actually not seated in time to participate in this case. So that means we have 3 sure votes for a stronger non-delegation doctrine, and Alito indicated that he's pretty much there as well. This issue isn't going away, and all eyes are on Kavanaugh. Adam and Michael, any predictions?
Well, my main prediction is that this is going to unleash a nearly decade-long debate, especially on the right, about the non-delegation doctrine. I think of Gorsuch's dissent in this case a lot like Justice Scalia's concurrence in Talk America, the case that spurred the entire debate around Auer deference for nearly a decade. We all knew where Justice Thomas stood on the non-delegation doctrine. He's been voicing doubts about the current doctrine since 2001. Like you said, we knew Gorsuch was a skeptic, but getting those two plus Roberts, plus a signal from Alito that he's open to reconsidering these things, and then Kavanaugh himself has raised questions in a few places. I think we're going to have a very interesting debate, especially on the within the conservative and libertarian legal movement over what this is. This is such a challenging doctrine. How do courts draw lines between a statute that's just kind of vague and a statute that's so vague as to be an unconstitutional delegation of power? Justice Scalia, going all the way back to before he was even a judge, back when he was at my new home, the American Enterprise Institute, he wrote an essay once on what was called the benzene case, saying the non-delegation doctrine is extremely important. It's also the kind of thing that courts are uniquely ill-suited to actually enforce. And so now conservatives and libertarians are going to have to grapple with that. And, Justice Gorsuch's dissent, it lined out some general principles, but it's definitely not a straightforward test for courts to apply. And I think the conservatives and libertarians have a lot of work to do to explain what the proper test is and how it overcomes just the basic problems of asking judges to draw lines that aren't themselves clearly stated in the Constitution.
I think about the question in part as a practitioner and agree that I think we're going to see a lot of litigation coming up over the next few years and perhaps decade on this question. Very much like we did see in the run-up to Kaiser against Wilkie. We saw sustained opinions by justices on the court, writing concurring and dissenting opinions about it. Also among the courts of appeals, judges writing concurring opinions, acknowledging that they have to go along with a particular outcome, but lamenting that the basis for getting there is just not supportable. I think we're going to see more and more litigants putting a Alito concurring in judgment in Gundy kind of argument forward. And I think we're going to see more and more judges on the courts of appeals, not just the Supreme Court, laying out ideas about how to deal with it.
In some ways, at the end of the term, I saw real sort of intellectual connection between this case and another case decided within the same day or a couple of days before. That was the partisan gerrymandering case. There was two of them. One was called Rucho versus Common Cause.
You may or may not know that I litigated that.
Oh, that was
case.
your case?
Yes.
I didn't know that. That's why I see your eyebrows go up. Here's my basic view of the similarity, and I don't want to overstate it, but I think it's important. With the partisan gerrymandering case, people bringing the lawsuits, they spotted a fundamental problem within our political process, one that doesn't solve itself, right? That the politicians are not going to draw these lines neutrally. They tried to come up with some lines that the courts could apply. You'll know that the standard that was sort of developed in the last few years about the delta between a voting bloc's actual political power and the outcomes they're seeing in elections.
The efficiency gap.
Right, the efficiency gap. And so you see these efforts to construct this standard that courts can apply. And ultimately the Supreme Court in this case, in this current iteration of litigation, said, we're just not convinced that's the right standard. We're not convinced that there's any standard here for the court to draw. And therefore, we're going to leave this to the political process for better or pretty clearly for worse, acknowledging the real problems. In some ways, that has echoes in the non-delegation doctrine. You see in this case people on the right and among the libertarians arguing that the non-delegation doctrine or the problem of delegation is a problem fundamental to our political process. It's really distorting so much of lawmaking in America. There has to be a solution, and Congress is not going to solve itself. Congress likes delegating power. It doesn't like taking responsibility for these arguments. So people look to the courts and say, you need to draw a line. I think conservatives who want to push for a reformed non-delegation doctrine need to study very closely the problems that the critics of partisan gerrymandering encountered in litigation. Because I think, again, it's obviously a problem at a constitutional values that requires a real solution. But courts, for the same reasons they were reluctant to draw the lines in common cause, I think they're going to be very reluctant to draw these lines on non-delegation. Even justices like Alito, Roberts, and others who are spotting problems now. When we get to that actual case many years from now, it'll be interesting to see if they actually draw a line. Does that sound closer to what you saw?
It's an interesting observation. I guess, what I would say in response is, in effect, what Justice Kagan said in her dissent in the gerrymandering cases. That it may be difficult to draw the line doesn't mean that you can't tell when you've got a clear constitutional violation in front of you. I can think off the top of my head of a handful of cases where I think there are clear non-delegation problems, where agencies are being given the power to legislate substantive policy that does not belong in the hands of the executive. And bringing those sorts of cases to the court, it'll be interesting to see. Those cases are going to get to the Supreme Court, whether tomorrow or 10 years from now. And it'll be interesting to see how, as you say, those who sided with the Chief Justice's opinion in the partisan gerrymandering cases react, because I would say in the partisan gerrymandering cases there was a clear constitutional violation in these cases, and courts have to resolve cases one case at a time. It'll be interesting to see whether they stick to their same principled guns when it comes to the non-delegation cases.
Yeah, I think it's ironic that the court is so concerned about its legitimacy being harmed by wading into areas where there might be difficult line-drawing problems, but it hurts its legitimacy just as much when it refuses to address violations that everybody can see are present.
Exactly.
Yeah, but it's one thing to say that we all see these problems, or that we see cases that are very difficult to sort of shrug off, real pressing constitutional problems. The challenge for the courts is, by stepping onto the field at all, right, it's easy to sort of identify that there's a pull. Right, at one end is in the non-delegation context, statutes that are written with minute precision. And then there's a statute like the one you identified earlier, right? That we always point to things like the
FTC Act,
the public interest standard, things like that. But once the court says we're going to draw a line, they have to be confident that they can draw lines in the cases that aren't so obvious, right? Sometimes I'll leave it at that, and I think that's what they're worried about. I think Kagan made great points in her dissent. The challenge for proponents of the non-delegation doctrine are to make sure that they don't wind up sort of celebrating a dissent, right? That they want the argument to make it into the majority.
Yeah, I think that's all. It's an interesting perspective. As a litigant, I'm always thinking about the cases that are before me, and I think traditionally that's how courts have operated too. Courts decide, as I said before, cases one at a time, and I think where in these broad and important areas of constitutional litigation, partisan gerrymandering, non-delegation, where there's something close to a blank slate, less so in non-delegation, although the way that it's been litigated really since the 1930s is anything's okay, so maybe a bit of a blank slate, is I think judges and justices get tripped up over this need to announce a grand unifying theory in one fell swoop that will answer all cases for all time. And that is not traditionally how litigation works. The way litigation traditionally works is courts decide the case before them. And maybe the way that they decide the case before them raises questions about future cases that are coming down the line, but deal with those questions when they come up then.
I remember Nick Bagley, a very smart professor at the University of Michigan, after Gundy was decided and Gorsuch issued his opinion, Bagley said, I think it's wound up in a New York Times op-ed, that what Gorsuch is doing, if it was actually adopted by conservatives in a case, would cause huge uncertainty through modern administration, right? If they struck down, say, a portion of the FTC Act as violating the non-delegation doctrine, yeah, it's deciding just that one case, but every other agency with a statute looks anything like it, the FCC, the CFPB, all of them, it would send a shockwave through. And I remember I kind of kept that in mind, and because when that case came out, I think we were thinking also about partisan gerrymandering, and it just struck me that Bagley's concerns about judicial intervention on non-delegation, they just sounded a lot like my own sort of internal monologue worrying about judicial intervention and partisan gerrymandering.
Very true, and I think if the court had adopted a test for partisan gerrymandering in Rucho and Limon, or if it had come out the other way on Gundy, no doubt there would be significant ripple effects. No doubt there would be a perhaps extended period of adjustment, and those are all very serious concerns, obviously, that are on the justices' minds.
I think a big question about Gorsuch's position is sort of left open because he suggested that Kagan's interpretation of the statute would itself raise non-delegation problems. You recall I mentioned that she had a significantly narrowed reading of the statute. And if he really means that, then this is an extremely aggressive reading of the non-delegation doctrine. If he doesn't, or if he's just suggesting that, well, there might be some issues there, then maybe not, because even Kagan indicated that she thought there would be a more difficult question if the statute were as broad as the petitioner was arguing. One more point on what Michael was saying earlier with regard to case-by-case adjudication. A point that we were making in our amicus brief before the court is that the non-delegation doctrine is actually alive and well in the state courts, is litigated around the country on a pretty regular basis, and the success rate on non-delegation claims in state courts that do have a real non-delegation doctrine is pretty comparable to the success rate on other constitutional claims, First Amendment, Fourth Amendment. It's in the teens. And of course, there are difficult cases, but the doctrine is developing case by case. It starts off with a broad principle, and then you start to get a lot more specific rules about particular kinds of statutes, and it seems to be working just fine. So we'd like to show that to the Supreme Court again the next time this issue comes up, because I think hopefully it will reassure them that there is a way to approach these seemingly difficult problems in a more incremental way.
I think in a lot of the things we've talked about today, we really do need to look to the states as laboratories of democracy, or as you guys might say, laboratories of liberty. So much of the debate around administrative law or the administrative state is about striking a balance between competing priorities, rule of law versus democratic accountability versus technical judgment, worries that if they modify, say, a deference doctrine, it's going to have real ramifications for how the agency does its work, for better or for worse. I think those are all in some ways empirical questions, right? Not totally, but we ought to look to the experience of states and really see how these things are happening. I know that Arizona, where your co-founder, Clint Bullock, is now in the state Supreme Court, the state, I think, did away with their version of Chevron deference. It's going to be a very interesting experiment at the state level. And I think the challenge for those of us who sit here inside the Beltway and think just about federal administrative law is actually sort of, looking out a window at the country at large and see what we can actually learn from what they're doing.
Okay, that concludes the show. Thanks to Adam and Michael for joining us and to you for listening. Until next time, we statutorily authorize you to get engaged.